A warm greetings from Law and Life. I'm today's host Shashank Mishra with Subodh Markandeji, who is renowned senior advocate of Supreme Court of India. In this video, we will be discussing the case which was mentioned in episode number 18, where we have discussed about the Article 142 of Indian Constitution. Now, my first question on this topic is, the Supreme Court of India has invoked the provision of Article 142 in AG Perarivalan versus State of Tamil Nadu, Criminal Appeal number 833 of 2022, decided on 17 May 2022. So, what is this case?
So, in this case, the appellant was accused number 18 in crime number 329 of 1991, registered in the police station Sri Perambadur in Tamil Nadu. It's a case where the former Prime Minister Rajiv Gandhi was assassinated on 21st May 1991. The accused conviction and death sentence given to him by the trial court and Madras High Court were upheld by the Supreme Court of India, and the review petition filed by him was also dismissed on 8th of October 1999. Mercy petition was filed before the President of India, which was also dismissed on 12th of August 2011. Challenging the rejection of mercy petition by the President, he filed a writ petition in the Madras High Court, which was transferred to the Supreme Court of India by an order dated 1st May 2012. Now, on 18th of February 2014, while considering the said writ petition, the Supreme Court commuted, this is important, commuted the appellant's death sentence to life imprisonment. On 18th of February 2018, the Supreme Court also directed the concerned authority to dispose of the appellant's petition dated 30th December 2015 under Article 161 of the Constitution of India. On this petition, the Council of Ministers of Tamil Nadu, by a resolution dated 9th of September 2018, recommended the release of the appellant, which was sent to the Governor of Tamil Nadu for his formal approval. This petition under Article 161 was the subject matter of adjudication by the Supreme Court in the instant criminal appeal number 833 of 2022, which has been allowed by the Supreme Court on 17th May 2022.
So,
So
what were
these
the
are the
question?
facts.
Sir, what were the question for consideration before the court?
I think some more facts will also have to be noticed. Since the investigation was done by the Central Bureau of Intelligence, the state of Tamil Nadu, by its letter dated 19th February 2014, sought the views of the central government on the proposal of the state government for the remission of sentence of the appellant in terms of section 435 of the Code of Criminal Procedure. On this application of the the application of the central government, the Supreme Court on 20th February 2014 directed the maintenance of status quo. The Union of India filed a writ petition to quash the letter of the state of Tamil Nadu dated 19th February 2014, which was referred to the Constitution bench, that particular case. The Supreme Court, by its judgment dated 2nd December 2015, answered all the questions which were framed by the Constitution bench. So, during the pendency of this matter, the Supreme Court was informed that the governor had not taken any decision on the resolution of the Council of Ministers of the Tamil Nadu to release the appellant. On 21st January 2021, the Solicitor General of India informed the Supreme Court that the governor would take a decision shortly. But instead of that, On 4th of February 2021, an affidavit was filed by the Union of India that by an order dated 25th January 2021, the governor held that the appropriate authority to grant remission was the president and not governor, and hence the case was sent to the president for orders. So these are the broad facts. Now, what happened that on 9th of March 2022, the Supreme Court passed an order releasing the appellant on bail in view of the following facts: that he has served out 31 years of 31 years of imprisonment, that his conduct throughout was very good, and that he had acquired several educational qualifications during his imprisonment. And lastly, the evidence on record showed that he suffered from various ailments. Now, coming to your question, the only point for consideration before the Supreme Court was whether the reference of the case made by the governor to the president on 21st January 2021 was correct or not. The Supreme Court held that the governor had no option, as various decided cases had laid down that the governor was bound to act as per the advice given by the Council of Ministers, and he could not, in law, make a reference to the president. In this connection, the Supreme Court, instead of remitting the matter to the governor for this formal approval, which he was bound to give but had failed to give for almost 3 years, exercised its own power under Article 142 of the Constitution and released the appellant, as he must be deemed to have served out his sentence. So, the exercise of power under Article 142 by the Supreme Court was a vital step to prevent further delay in the release of the appellant and in the furtherance of his right to life guaranteed by Article 21 of the Constitution. The Supreme Court released him. So, this is how the power under Article 142 was exercised. But I feel that an exclusive episode devoted to various aspects of Article 142 can be organized, and it will, I'm sure, prove to be useful.
Yes, sir. We will be looking forward of such episode.